Hello. Welcome to this webinar on biodiversity and cultural rights implications of the USMCA text and the GM corn case. I'm Karen Hansen-Kuhn with the Institute for Agriculture and Trade Policy. We will get started now. We have a few housekeeping issues just to make people aware of. First, on translation. In your webinar controls on the tool bottom at the bottom of your screen, you'll click on the interpretation button and then pick Spanish or English. En los controles del webinario, en la barra en la parte inferior de la pantalla, haga clic en el botón de interpretación en forma de globo y puede seleccionar el idioma que quiere. If you would like to hear the interpreted language only, click on mute original audio. Otherwise, you'll hear the language softly in the background. Para oír solo el idioma interpretado, haga clic en silenciar audio original. De lo contrario, oirá el idioma original suavemente de fondo. Okay, I'd also like to draw your attention to the Zoom webinar control buttons at the bottom, especially the Q&A function. You can ask questions of the panelists at any time by adding them in there and hitting send. We will gather questions and answer as many as we can by the end of the session. We won't be monitoring the chat function so much for those questions, so please do put your questions in Q&A. Also, this webinar is being recorded, so it will be available later on the IATP website. And we will be sending it around in English and in Spanish to everyone who's registered for this webinar. I think that should happen within the next week. And finally, we hope that you will join us for the final webinar in this series, which will happen next Tuesday, May 7th, where we'll look at the economics of the USMCA corn case, that is, farmers' livelihoods and perspectives. So let's get started. Okay. So the Mexican government announced its plans to transition away from glyphosate and imports of genetically modified corn shortly after President López Obrador took office in 2019. These actions were part of a series of programs designed to increase food self-sufficiency and transition to agroecology. The initial decree called for phasing out glyphosate and eliminating imports of corn by 2024. A revised decree was issued in February of 2023. In that version, glyphosate is still phased out over perhaps a longer time period, and there is a ban on the use of GM corn for human consumption, especially flour and tortillas. There is also the intention to move away from imports of genetically modified corn for other uses as supplies become available. The U.S. government launched a formal trade dispute against these plans last August. Mexico is a center of origin and constant diversification for corn, with more than 60 native varieties under threat of contamination. In this webinar, we'll explore the effects of GM corn on Mexico's biosafety and biocultural heritage, as well as the basis for protection of biodiversity and the rights of indigenous communities that are signaled in the USMCA text. The organizations involved in this webinar have each submitted formal comments as part of the dispute process. So we'll begin with David Rivero Fragoso. David, are you there? There you are. And Lily, can you make his video bigger? It looks like you are. Or maybe it's the way I'm doing it. Sorry, it's my view.
Oh, when he starts talking, he'll take over the screen.
Perfect. So David, Rivero Fragoso is with the Grupo Vicente Guerrero. He's a specialist in international human rights law with a focus on gender, restorative justice, social and collective rights. He has worked in the defense of collective rights against the planting of GM corn in Mexico and the conservation of biodiversity. He is a member of the National Without Corn, There Is No Country campaign. David?
Thank you so much, Karen. First of all, thank you for the invitation to participate in this webinar. Thank you to all of the co-organizers. My presentation is going to focus on the impacts of the importation of GM corn. GM corn is the term that I'm going to use. And that refers to the GM corn that is being imported under the free trade agreement. We have to determine who is responsible for the impacts of GM corn that is imported under the USMCA on the communities of Mexico. And what are the implications? I'm sorry, it is breaking up a little bit.
David, hay problemas con el audio. ¿Puedes hablar un poco más despacio y fuerte?
In Article 4, stipulates that when there are impacts on the health of the population, the Article 4 stipulates that there has to be a harmonization of the rules on the impacts for the health of the inhabitants in both countries. But because of the differentiated patterns of corn consumption between the United States and Mexico, there are differentiated impacts of GM corn on consumers in Mexico. %40 of the diet of Mexican population is based on corn. Under the USMCA, in Article 13.3 addresses the issue of corn and talks about the impacts for health and the environment. So in the USMCA, there are legal footholds for protecting the population's health and the environment. Furthermore, there has been difficulties in protecting native corn from GM corn contamination. Unfortunately, the market is such that when corn is sold, all the different varieties, including GM corn, are mixed together. And so it's impossible to separate them. 60,000 tons of corn was exported to China. But the United States was unable to show that this corn wasn't contaminated or separated. I'm very sorry, but it's really hard to hear.
David, hay problemas con el audio todavía. ¿Es posible usar audífonos o algo?
Or I think he should take his earphones off and just use the mic from the computer.
Así que utilizar el micrófono de la computadora.
In 2020, when the USMCA was already in effect, can you hear me? Can you hear me? He's asking. So there was a debate about the degree of minimal protection of the corn for that any entity or country that wanted to import corn to Mexico had to comply with. So the evaluation of risks has to include the impacts on the Mexican population who consume corn. Even in junk food, corn is used, and that has to be taken into account in any kind of impact assessment. There are also agricultural and agroecological practices that have to be taken into account in, for example, how seeds are saved, how seeds are exchanged, especially in communities of indigenous peoples and peasants. The United States neglects to mention that Mexico allows for, I'm sorry, I cannot hear. It sounds like somebody's hammering. Can you please turn off the other microphones? In Mexico, there are a number of lawsuits that are pending while the trade dispute is pending. We do not have statistics and sufficient proof of what the long-term impacts of GM corn contamination will be. There is traces of GM corn and food for human consumption, and the United States has so far been incapable to address the concerns that we've tabled about the risks for human health and the environment. Thank you.
Thank you, David. I hope the translation was working. I know there was some issues, but hopefully these things come and go. Hopefully it will get better as we go along. But great presentation. Next, we'll have Monserratt Téllez. She is the Political Advocacy Coordinator of the Seeds of Life Foundation and member of the Without Corn, There Is No Country campaign. She works to influence the transformation of the global agri-food system, focusing on the process of corporate privatization of seeds and the defense of seeds by campesinos. She collaborated in the Center for Global Change and Sustainability, was a thematic advisor in the Mexican Chamber of Deputies, and coordinator of the alternative market of Tlalpan. Montse, please go ahead.
Thank you, Karen. Good afternoon to those of you who are in the US, and good morning to those of you who are in Mexico. There are a number of key issues that we need to table for our consideration. We have the biocultural heritage, we have environmental impacts, and especially impacts for biodiversity, which are key concerns for this trade dispute that the United States is trying to exclude from the discussion and the arguments before the tribunal. Civil Society of Mexico, the United States, and Canada have requested that written comments and technical opinions be accepted about these impacts for biodiversity, the environment, and biocultural heritage. But there are efforts to exclude the whole issue of these impacts. And we note that in the latest comment from the United States, there is a line of argumentation to the effect that they want to continue to exclude these considerations from the deliberations of the tribunal. And a few days ago, on April 23rd, the United States responded to Mexico and insisted that the whole issue of impacts for the environment should not be included. And in the case of ANEC, their written statement was restricted with regard to its discussion of environment. Of course, this plays into the hands of the U.S. seed companies and government. And obviously, for the Mexican government, the impact on the environment is one of its key concerns and reasons for its decrease. David, the previous panelist, has explained that 40% of the Mexican diet is based on corn, more than 1,000 calories a day. So it's each typical Mexican consumer consumes 200 kilos a year. That's almost half a kilo a day. And obviously, corn is a pillar of traditional Mexican cuisine. Mexico is the center of origin and diversification of corn. It has more than 60 varieties of native corn. So, as David said, on one hand, the U.S. has not proven that its studies on and its impact assessment does not take into account the level of and quantity of corn consumption of the Mexican population. On the contrary, there's 20 years of literature which shows that GM corn contamination has occurred in Mexico precisely from the GM corn that has been imported from the United States. And this has had adverse impacts on the biocultural heritage of our country. 59 of the varieties of corn in Mexico are native varieties. 300 generations have transmitted traditional knowledge systems based on corn and about corn. But when we talk about biocultural heritage, we have to be very holistic. We're talking about ancestral practices and entire cultures that are centered around corn and its genetic resources. So this is a crucial concept to address, because in the USMCA, they only think of or conceive of corn in terms of genes or a genetic resource. And they compared GM corn as they treat it as if it was just a hybrid. They treat them in the same category and don't make a distinction about the adverse impacts that are specific to GM corn. And furthermore, the whole U.S. framework is focused on profit for corporations, whereas here in Mexico, we focus on the defense of ancestral cultures and the biodiversity and the free exchange of native seeds and the defense from GM corn contamination. So obviously the impacts on indigenous peoples and peasant communities and biodiversity in the environment is absolutely a central issue. And the fact that the United States doesn't want to recognize that is unfortunate. The United States contends that one of the arguments from civil society in Mexico, as well as the Mexican government, is based on Article 20 of the GATT, which stipulates the prerequisites for trade. And the protection of non-renewable resources. So this contradicts the US's position about discarding the importance of the impacts on the environment of GM corn. Obviously, the tortilla is part of how corn is a pillar of our diet. The native corn varieties are considered non-exhaustible, but that contention is based on only one study in Puebla and Oaxaca. But the research on the presence of GMOs was very limited. But there are a host of other studies that document conclusively GM corn contamination throughout Mexico. In 2004, the Commission on Environmental Cooperation concluded that in Mexico, the source of GM corn contamination was from the importation of GM corn from the United States. And to avoid studying and documenting these risks and adverse impacts is denying that the source of the GM corn contamination is precisely the GM corn imports from the United States. So the United States clearly is lying through its teeth. Furthermore, the U.S. has also wielded false premises in other trade disputes. For example, in its dispute with Argentina, it argues that non-native corn is a risk, not just GM corn. But nonetheless, we counter that the complexity of GM corn is not similar to other non-GM corns. It has very specific adverse impacts. And the difference between conventional corn and GM corn have not been duly studied. And furthermore, when there are phenomena of mixed contamination, that hasn't been sufficiently studied either. The United States has not proved the impacts of glyphosate in the population and the environment, because obviously some of the varieties of GM corn are glyphosate resistant. So it is also important to include studies of the impact of glyphosate. And in the latest text that Mexico tabled, that there would have to be a restriction on national production to restrict GM corn contamination. Well, Obviously, both civil society as well as the Mexican government are countering the false premises and false basis of the United States position. Thank you.
Thank you so much, Montse. Our next speaker is Sharon Anglin Treat, who is a lawyer and public policy analyst with expertise on trade policy. She provides legal and policy advice through Norumbega strategies on food, environmental, and public health issues. She's a senior advisor to the Institute for Agriculture and Trade Policy, where she was senior attorney from 2017 to 2022. Ms. Treat served on the Intergovernmental Policy Advisory Committee in the Office of the U.S. Trade Representative for 10 years and is a former member and chair of the Maine Citizen Trade Policy Commission. She will be speaking, drawing from the brief that IATP submitted along with the Rural Coalition and the Alianza Nacional de Campesinas. Go ahead.
Okay, great. I'm going to be sharing my screen so I can do some PowerPoints. So let's see how it works. That looks like it works, right? Okay, good. So good morning, good afternoon. I'm really excited to be part of this really important series of webinars. I'm going to be talking specifically about a new provision that's in the USMCA that was not in NAFTA. It's Article 32.5, and it's about indigenous legal rights. This is the first time that there has been a provision like this in any trade agreement involving the United States. And so we're going to find out in this dispute whether it has meaning or whether this is really just put there to make political hay and look good. There's a little backstory to this provision, and it's important in terms of understanding how to interpret it. The provision comes from the Canadian government, whose negotiators advocated for this provision. And these are some quotes from their website where they take, great pride in this particular provision. The clause was very much supported by and advocated for by Indigenous advocates in Canada. And this is a quote from Perry Bellegarde, who is then the chief of the Assembly of First Nations in Canada, and was on an advisory committee to the Canadian government about the trade negotiations. As he says, this provision assures the parties freedom to meet their legal obligations to Indigenous peoples and to act in the interest of Indigenous peoples, without the concern that such actions may run afoul of trade or investment rules, meaning that one state cannot bully the other at the cost of Indigenous people's rights. As I said, there was no such provision in the earlier NAFTA agreement, which USMCA updated. There is a provision in the Trans-Pacific Partnership, which is actually both Mexico and Canada are part of that. And it's a provision that was secured by New Zealand, which was focused on the Maori people and the treaties that they have there that they wanted to ensure could be implemented. There's been concerns about the earlier language because it has been interpreted to be fairly narrow and really to just apply to things like duty-free treatment of Indigenous handicrafts, as opposed to broad provisions similar to what we're talking about here that the Mexican government has implemented. This is the language that is in the USMCA. It's Article 32.5. It starts with a provision saying that you cannot use the Indigenous peoples exception as an excuse to actually discriminate against other parties or to restrict trade. But assuming that that's not the case, what this provision does is it says it doesn't preclude a party from adopting or maintaining a measure it deems necessary to fulfill its legal obligations to the Indigenous peoples. This is a very broad provision. It applies to all aspects of the USMCA. And the idea is it's an affirmative defense. That means even if a dispute resolution panel finds that there's been a violation, for example, of the SPS obligations, the measure that is challenged can still be upheld if it meets the indigenous people's legal obligations exemption. The USMCA negotiators changed the language that was in the Trans-Pacific Partnership, and they got rid of the language that was ambiguous and narrow, and they changed it to measures that a country deems necessary to fulfill its legal obligations. This particular language is considered to be self-judging. What that means is that each party gets to decide the scope of their own protections for indigenous peoples, and not another party or the dispute panel. And it's actually quite similar to the type of language that is in these trade agreements concerning national security. And I note that Canada agrees with this interpretation that this provision is self-judging. And we'll get to more on Canada later. Also relevant is a new provision that's in the USMCA relating to trade and biodiversity. And this very directly connects to the presentations we've already heard today on biodiversity. There is a provision, Article 24.15, and paragraph 3 says that the parties recognize the importance of respecting, preserving, and maintaining knowledge and practices of indigenous peoples and local communities embodying traditional lifestyles that contribute to the conservation and sustainable use of biological diversity. Now, this is not a general exception, just like the indigenous peoples provision, but it is very important language that can be used to understand the scope of the indigenous peoples exception, and to understand that trade and biodiversity is part of what that particular article is looking at. So to invoke this exception, as Mexico has done, and as we argued in our submission, you have to have laws that protect indigenous rights. And in this case, Mexico does have those laws. Mexico's constitution has several provisions that recognize indigenous peoples and rights. The Constitution also guarantees all individuals the right to a healthy environment and to health. And we heard a great deal about this both today and last week in the webinar that we had already. There's also federal law that protects cultural heritage and the resources of indigenous and Afro-Mexican populations. And very significantly, Mexico has ratified many international human rights treaties that protect indigenous people's rights. And I've listed a couple of them here. And what's important here is that in Mexico's system of government, international obligations are incorporated into Mexico's laws as soon as it's ratified. They don't have to pass additional laws to have these provisions take into effect. And this fact is recognized by the fact that judges in Mexico have relied on international provisions relating to indigenous peoples in their court decisions. Now, Mexico also has to show that its restrictions on GM corn and tortillas are necessary to protect indigenous rights. And we've heard today and also last week about the importance of corn, and I'm not going to go through all of these issues, but around the issues around nutrition, the issues around indigenous and small-scale farmers, maintaining the genetic diversity of corn, and the issues around the threats to biodiversity from GM imports. All of these things are part of the measures that Mexico has adopted, and they link to the importance of protecting indigenous rights. Mexico's measures are not disguised as trade restrictions or unjustified discrimination, and that's another thing that Mexico has to show. The tortilla ban addresses the use of corn. It does not restrict trade. It is not discriminatory because it applies equally to all countries, including Mexico. The substitution requirement for animal feed is not even in effect, and the U.S. growers have time to shift to production methods to grow non-GM corn if they choose to do so. And in fact, non-GMO corn sells for a premium. So it's quite possible that US growers shifting to that would be doing very well. Well, Canada has submitted a brief and it has commented specifically on the Indigenous people's rights exception. As I said, they agree that Mexico has the authority to decide for itself whether a regulation is necessary to fulfill its legal obligations to Indigenous peoples. But Mexico seems to want to have it two ways. They then question whether, Canada wants to have it two ways. Canada questions whether Mexico has acted in good faith and whether Mexico has substantiated that its obligations are rooted in law. And it notes that Mexico's measures protect the rights of non-Indigenous people along with the rights of Indigenous people. And so Canada says, well, this is unreasonable. It has broadened the scope of Article 32.5 in an unreasonable way. I would just say Canada's interpretation would dramatically narrow this exception, and it's inconsistent with the fact that this language was broadened differently from the Trans-Pacific Partnership in order to go to address not just these sort of narrow provisions that only favor Indigenous people, but to broadly address measures that in general are deemed necessary to carry out the rights of Indigenous peoples. As we've heard from Monse, the United States has issued its rebuttal. I haven't read the whole thing. I only went straight to the provisions dealing with the Indigenous exception specifically. And here's what the US says. As Monse said, they basically argue that Mexico has not shown that its measures are not being used as a disguised restriction on trade or a means of arbitrary or unjustified discrimination. So they're saying we don't even have to get to the issue of whether these obligations are necessary or whether the measures are necessary, because the first thing that is required under this exception is to show that it is not a disguised discrimination or restriction, and Mexico has not shown that, according to the United States. But then the US goes on to argue that even if the panel finds that Mexico's measures do meet the requirements of the Indigenous legal rights exception, the panel should still rule for the United States. Why? The US argues that it had a reasonable expectation at the time that the USMCA was concluded that a benefit that they expected to have, that they had at that time, would continue. And they say that they expected that Mexico would continue to use imported GM corn in tortillas, and therefore the actions of Mexico today, changing their laws, are causing a nullification or impairment of US expectations, and they cite to this other article. This interpretation could prevent any party from changing its policies after the date the USMCA was concluded. It seems to negate entirely not only Article 32.5, but many other provisions of the USMCA, if this dispute panel agrees with it. And I would note that Article 32.5, the Indigenous exception, specifically protects Mexico's authority not only to maintain policies, but also to adopt new measures. And it was specifically written in that manner. So it seems to be that the United States argument is extremely broad and quite likely to pretty much negate the usefulness of this particular article. So we're going to find out when the dispute panel rules, whether they're going to take this seriously or whether this provision is just window dressing, allowing these countries, particularly Canada, to go out and wave the flag and say that they're doing a good job protecting people when really it is just window dressing. Thank you.
Thank you, Sharon. Let's see. Okay, we do have some time for questions and answers. I saw one question that was put in the chat function. I would really encourage people to put your questions in the Q&A section. But anyway, one that I saw, somebody, I guess from the US, asked if it was, they thought maybe the TPP hadn't gone into effect. And I believe the case is that it did go into effect for all of the countries besides the United States. And I believe the UK joined last year. So there are other countries that are bound by that. I don't know if anyone else wants to comment on or to comment on each
I could
other.
comment on that.
Okay.
Could I comment on that? Because I think that that language is very important in the TPP because it has been interpreted, that exact language has been interpreted by tribunals in New Zealand. So they are looking at that language. So it is quite relevant to what is happening today in that the USMCA language is quite different.
All right. Are there also a reminder, we will be sending the recording around afterwards. Let's see. I'm not seeing other questions. So until we have some, I'm going to open it up to additional comments from the panelists. David, is there something you would want to add?
Thank you, Aaron. The Trans-Pacific, the TPP is relevant. And in fact, the texts are similar. New Zealand has brought on board the general exception on the rights of indigenous people. The United States obviously has been unwilling to. Something else that I'd like to touch on we're talking about Article 20 of the GATT. In paragraph G, there is some important jurisprudence that stipulates about natural resources that are not renewable. There was recognition that sea turtles are a non-renewable natural resource. Other non-renewable natural resources such as water and oil were also cited. In the case of Mexico, Mexico does constitute a non-renewable resource. Why? Because in Mexico, corn is a pillar of agriculture, but it is also the genetic reserve for the world, since it's the center of origin and diversification. So if the corn in native corn in other parts of the world is contaminated with GM corn, it is crucial that Mexico be like the world's seed bank for humanity. So the points that have been made about Article 20 of the GATT are really crucial.
So
Thank you.
before we go on to Monserratt, just a point of clarification that I saw come up in the Q&A. The current decree does not restrict imports of yellow corn for animal feed or industrial uses. It announces an intention to buy more non-GMO corn as supplies are available, but it does not restrict those uses. It does restrict, or there is a current ban on use of primarily white corn for human consumption, which Mexico imports very little of. So it's important to keep in mind that distinction, which is something that changed from the original decree to the revised decree last year. Monserratt, is there something you'd like to add? Or we can go on to some of the other questions.
Yes, thank you, Karen. What David mentions seems really crucial to me. Part of the argument of the United States government is the premise that Mexico has not proved that a relationship exists between protecting from GMO corn contamination and the protection of non-renewable natural resources. So language is necessary that includes the impacts for biocultural heritage on these the adverse impacts on biocultural heritage caused by GM corn contamination on non-renewable corn natural resources. So there's a timeline that I'd like to share with you in the chat that shows that the final decision will be issued in November 2024. So maybe the calendar will be changed, but that's what we should plan on. There's been a lot of review and translation of the documents related to the case. We have created a web page, maisnativo.org, which compiles all of the relevant documentation and translations. And it also includes documents about related issues.
I see a question directly for Sharon. Do you think there is a need to strengthen the rights for indigenous peoples' food sovereignty in future USMCA renegotiations? For example, would adding an affirmative right to food security and sovereignty in Article 32 be an effective path forward?
I think that as specific as it can be is probably, it's important to make the language as specific as possible. That said, the way this language is written right now is that it's up to each country to specify, and Mexico has specified that these matters of food sovereignty and diet and others are included in what are the appropriate legal obligations. I think the difficulty here is you could it depends what the panel is going to do. If they go with the United States second argument, which basically says, even if this indigenous people's legal obligation provision applies and protects Mexico's measures, it's invalid anyway, because the US had an expectation that Mexico wouldn't change its policies in any way respecting corn, and they have. And so the US is saying, well, this other provision just negates that entire exception, regardless of how it's written. So I think it's a very dangerous argument from the US because it's pretty much saying that, anything that they had in their minds at the time that the USMCA was concluded can't be changed. And if you want to talk about sovereignty, it's a direct attack on the sovereignty of Mexico in being able to enact its own policies that it deems to be important for their society, whether it's specific to indigenous peoples or anybody else. So, I think it's very concerning. Again, that said, your idea that the provision could be more specific to those things isn't a bad one, but it is written right now to be very broad and to cover many, many things without having to list them specifically, which sometimes is a good idea.
So we're almost out of time. I see there have been some questions about the science that was mentioned. I would encourage people to see the webinar we did last week, which focused on that particular issue and cited a number of studies. It may be that people have other issues as well. So I see one more question from Steve Supan about when a country has obligations. Mexico has obligations under the Convention on Biodiversity. If one party to an agreement has those obligations and another does not, does international law provide a way to clarify those differences? Or is that decided case by case? I don't know the answer to that. Any volunteers?
I don't know the answer to that either, but I do know that international treaties are part of Mexican law, and under the way this agreement is written, Mexico has a right to, implement measures that are part of their current legal obligations, and that treaty is part of Mexico's legal obligations, regardless of the United States, and it's recognized in that way in the article that I quoted from, the Biodiversity and Trade article. Specifically addresses that. It doesn't specifically mention that particular treaty, so that is the issue with the United States, which often doesn't sign on to the same treaties that other parties do.
Okay, we're almost at time. I would like to give, since Sharon's had a bit of time to talk, Monse and then David, time for any concluding remarks, and then we'll finish up. Monse?
Thank you, Karen. I'd like to invite the public to take a look at the materials that we're sharing as civil society from Mexico, Canada, and the United States. We posted in the chat the links to the compilation of these materials. You can see the response of the Mexican government to the United States, and you can also read the documentation from the hearings that have been organized in Mexico about the key issues of the trade dispute. And there's some expert opinions that are really worthwhile. And we look forward to the next webinar on May 7th. Thank you. Yes. Some of the questions that I saw in the Q&A, we didn't address because our focus in this webinar is on the impacts on cultural rights and biodiversity. But the whole question of risk assessment is important, as well as the impact of climate change on biodiversity and how native corn is more resilient to climate change and adapts better than GMO corn. And also, it's crucial to debunk the claims that GMOs are climate ready or drought resistant, because they're not. What the best seeds and crops are for adapting to climate change and resisting its adverse impacts are native seeds, be they from corn or other crops. And it's also important to highlight that the government of Mexico has detected other GM contamination in other crops throughout the country that are probably from imports. So there's several different varieties of GM corn that have contaminated Mexican corn.
I want to thank all of the panelists and our interpreter, Cassandra, as well as Lily, who is running the technical support. If there are any journalists who've joined this call, if you want to send an email to communications@iatp.org, we could put you in touch with the panelists if you'd like. We will be sharing the recording within the next week, and we hope you will join us for the next one. Thanks very much, everyone.